Welcome friends. Today we are here to discuss a very vital topic in Insolvency and Bankruptcy Code, section 32A, which was brought in to alleviate all the concerns of the resolution applicants relating to the legacy issues of the corporate debtor. The section 31, the approval of resolution plan by the adjudicating authority, already provided an environment to the resolution applicants as to how they will circumvent or circumscribe the liabilities, the surmounting liabilities of a corporate debtor when they take over that under a resolution plan approved by NCLT under the process of IBC. But the legacy issues like attachment of assets, the ongoing prosecution proceedings, the defaults and offenses committed by the corporate processor in the face of its insolvency, continue to haunt the resolution applicants, and in many cases the enforcement authorities like ED, CBI, Directorate of Revenue Intelligence continue to chase the new management and the corporate debtor for the proceedings that they had initiated, and even issued further summons for initiating fresh inquiries and proceedings even after the takeover by the resolution applicants. This was becoming a very big concern with the resolution applicants and was dampening the investment interest that they sought in the distressed assets, and therefore was becoming a grave concern for the investment climate in the distressed assets market space. Let us see what the IBC initially intended to achieve. The IBC is a complete code for resolution of distressed assets, the companies in distress, by way of reorganization and beginning in a mechanism of insolvency resolution. One of the foremost objectives is that the process is to be run in a mechanism by providing an environment that the value of the assets can be maximized and interest of all stakeholders is balanced. One of the vital stakeholders who bring in the value realization aspect of the IBC is the resolution applicant, and they are very much concerned when some investigating authority keeps on questioning them of the past proceedings, the past of the corporate debtor. They wanted a clean slate to start with the process of revival of the corporate debtor, and if such a clean slate can be provided, there would be more interest in the assets, more people will be able to and willing to participate in the process of resolution, and when there will be more participants, there will be competition, and thereby the value of the assets would be maximized. Let us have an overview of how the IBC process operates, and then we will place what is the relevance of section 32A in achieving that. The IBC process at the first and foremost stage puts the management of the assets of the corporate debtor, the business of the corporate debtor, in the hands of an independent professional, that is the resolution professional appointed by the NCLT. This helps in alleviating the concerns that if an investor is willing to take over a company which is in distress and revive it, he doesn't have to deal with the ex-management. The custody of the assets will be with an independent professional. He will have to deal with the resolution professional and committee of creditors, and he can be rest assured that resolution professional will hand over all the assets of the corporate debtor to him in a good state. Second pillar of the IBC is the process of inviting claims. This helps in building a information memorandum, assessment of what all liabilities the corporate debtor has attracted, whether they are well represented in the balance sheet, and even if they are not well represented in the balance sheet, there is a process of public announcement. Anybody and everybody who has a claim against the corporate debtor, that can be made to the resolution professional, and he verifies it from the records of the corporate debtor and makes a compilation. Resolution professional also does the task of ascertaining all the aspects related to business and assets of the corporate debtor, makes a compilation of that, and develops a white paper on the corporate debtor, the business, the assets, the processes, the tangibles, the intangibles. This helps a potential resolution applicant to ascertain what all is the asset value, what all is the business value, and what investment proposition he can make to the corporate debtor, to what all investment he can make for revival of the corporate debtor, what all things he will need to do, what are all the gaps, and he gets a good starting point for his deep dive diligence so as to come up with a resolution plan. The IBC is designed as a market led process. The opportunity that is there for revival of a corporate debtor which is in distress is placed in the public. There is a process of invitation of expression of interest. Anybody who has the wherewithal and meets the criteria approved by the committee of creditors can put in an expression of interest. And in the marketplace, who all are the eligible applicants? They come up with their best ideas, best resources, and make their best case for revival of the corporate debtor through submission of a resolution plan. Amongst multiple people who make the proposition for revival of the corporate debtor by way of a resolution plan, the committee of creditors enters into a process of negotiation, picking up the best resolution plan in terms of the proposition, in terms of the settlement of the stakeholders, in terms of the feasibility and viability of actual implementation of that resolution plan. The best suitor, of course, finds the favor with the committee of creditors. Committee of creditors, through a vote of 66%, approves the resolution plan. And of course, thereafter, since this is a quasi-legal process, there is a requirement of approval of the adjudicating authority, which is National Company Law Tribunal. National Company Law Tribunal reviews the entire process, sees that all the processes were duly followed, all the stakeholders' interests as guarded under the law have been protected, the valuation exercise has been carried properly, all the checks and balances have been verified by the resolution professional, and it has been duly voted upon by the requisite percentage of vote by the committee of creditors. Now, the significance of the approval of adjudicating authority comes by way of provisions of section 31, which provide that once it is approved by the adjudicating authority, the resolution plan will be binding on all the stakeholders. Now, the implication of this is that an investor, a resolution applicant who is presenting a proposition for revival of a corporate debtor does not have to go and individually settle with all the stakeholders and negotiate on a one-to-one basis. Once the resolution plan submitted by him is approved by the adjudicating authority, that becomes binding on all concerned. No individual can stand up and say that he does not accept it. At best, the remedies go to NCLAT and file an appeal. And this feature of section 31 that makes it binding on all concerned enables the resolution applicant to circumvent his liabilities, obligations, and the investment that he has to make and commitments he is making in respect of the for revival of the corporate debtor. Therefore, he can very well envision what will be his commitment, what is the financial outlay, and then evaluate what is the prospective return that he can get out of the corporate debtor and endeavoring in the of his assets for revival of the corporate debtor. But one concern has still remained and struggled. All the liabilities, the contracted liabilities, the legal contractual battles, the contingent liabilities, all that can be covered under a resolution plan. But what does the the resolution applicant do? What his obligation or what his stake would be if there is a ongoing prosecution proceeding against the corporate debtor and there are fines and penalties, and in certain cases even prosecution for directors and management is also provided under such statute. If those implications are also attracted by virtue of his investing in a distressed company, that will be a very unpromising and unwelcoming situation for him, and a large number of resolution applicants would get disinterested or shy away from making any proposition, and would feel that since they are good businessmen, they have never committed any offense, why they should get into such hassle of getting the investigating proceedings and feel the consequences where they have not done any wrong. IBC, when it was enacted on 28th May 2016, it did not address this gray area and this concern of the potential investors or resolution applicants. IBC Amendment Ordinance 2019 was brought in on 28th December 2019, which subsequently culminated in IBC Amendment Act 2020, which was brought on 13th March 2020. And the amendment that was brought to address this grave concern was Section 32A. Section 32A was brought to address two concerns. The first concern was regarding the ongoing prosecution proceedings, which could result into a certain penalty or sentence, and the repercussions against the assets of the corporate debtor, in which the resolution applicant or the investors are actually making the investment. So Section 32A seeks to address both these concerns. It seeks to provide immunity to the resolution applicants, the bona fide resolution applicants, to that they will not be prosecuted against, or the corporate debtor, if any prosecution proceedings are going on, they will not be continued against the corporate debtor. And secondly, if the assets of the corporate debtor have been made subject to any attachment proceedings, that attachment will automatically go off, and those will not be subject matter of attachment anymore. Of course, Section 32A, when it was brought in, it had this object in place, but with checks and balances, that scrupulous people who try to get back their companies after having defaulted on the loans, who were actually party and responsible for the offenses in the first place, they should not get scot-free. They should not use the process of approval of resolution plan and immunity provided under the Section 32A to get rid of their offenses. This is what the objective of the Section 32A when it was amended. It was to provide immunity against prosecution of the corporate debtor, to prevent action against property of such corporate debtor and successful resolution applicant, subject to fulfillment of certain conditions. Now let us see what these conditions are and what is the ambit of protection of Section 32A. The first leg of Section 32A subsection 1, as I mentioned, the first aspect is the concern of the resolution applicants that a company which is in distress, a company which has been in hands of a management who have been charged of siphoning of funds, of wrongdoings, of non-compliance of provisions of Act, and in many cases of insolvency, a company which is in distress, it will more or less fall into a backlog of compliances, which then would attract penal provision under several acts like Companies Act, Income Tax Act, Excise Act, and so on. All these legacy issues, once the company is taken over, the resolution applicant has invested his money, he has brought in new sets of hands-on board, new managerial person who have taken over, he is exploring new marketplaces for the product, he is investing into the working capital, he is investing into reviving the operations. He doesn't want to get entangled with the investigating proceedings and the proceedings jamming the operations, jamming the management bandwidth once again. The immunity that 32A provides, that insofar as the corporate debtor which has been taken over, its liability in respect of any proceedings which were going on prior to commencement of CIRP, that shall come to an end. The section through a proviso further provides that even if during the CIRP some process has been initiated, even that process will come to an end. And this cessation will be automatic from the date of approval of resolution plan under section 31 by the adjudicating authority. So on one hand, the provisions of the resolution plan qua the various claims will put a limitation on the settlement amount that is payable for the liabilities of the corporate debtor. The fiction of the law provided under section 32A, the immunity that is provided, will also bring to an end on an automatic mode all the proceedings, ongoing proceedings that were continuing against the corporate debtor from the date of approval of the resolution plan. Now, certain conditionalities have been provided under section 32A to ensure that this section is not taken advantage of by people who were in first place responsible for commission of those very offenses. So to ensure this, certain set of peoples who have been excluded from this immunity are, the condition is the change of management should have taken place. If through a resolution plan the management continues to be the same and the same very person are managing, and this is very much possible because now under section 240A the for MSMEs certain MSME companies, the promoters have been exempted from certain clauses of section 29A, so they can very well come back into management, and certain managements may not be ineligible for putting up resolution plan. But in case the management change is not happening through section 31 plan, then immunity of section 32A will not be available and offenses will be prosecuted as they would have been as if there has been no change of management. In case the investigating authorities have reason to believe that certain persons are responsible for the offenses, those persons will continue to be prosecuted and the immunity will not be available to them. But this belief, this reason to believe has to be based on material on record. It cannot be a enveloped belief that yes, possibly even the change management could have participated somewhere. If there is material on record that some shareholders, some persons in the new management as well were responsible or could have contributed and there is some overlap, and investigating authorities can make their case that they have material to substantiate their belief, the proceedings can be continued against them. As mentioned, it doesn't protect the designated partners in case of a LLP or a officer in default in case of a corporate person for the offenses. Now friends, the objective of the immunity is to protect the resolution applicant who has a bona fide proposition of investment, a commercial investment, and provide him a clean state and encourage more and more resolution applicants to participate in revival of the corporate debtors. However, the intent of law is nowhere that the proceedings should come to an abrupt end. The proceedings will very well continue against other persons who have been responsible for the offenses, but for the corporate debtor, and for investigating if any cooperation is solicited or any records are solicited from the corporate debtor, the resolution applicant, the new management, they have an obligation to provide the assistance that may be required by the investigating agencies. The next leg of immunity that is provided by section 32A subsection 2 is qua the assets of the corporate debtor. Now for most resolution applicants, this is even more significant and immediate immunity that they required. In fact, this immunity emerged, the requirement for this section emerged from developments in certain large insolvency resolution cases where the resolution applicants had already taken over the corporate debtor. However, they were not able to take complete charge of the assets of the corporate debtor because certain investigating authorities had attached the assets of the corporate debtor, and thereby the resolution applicant was put to grave prejudice that the very assets for which they have invested the money, they are not able to realize those assets. The assets for which they have done their due diligence, now certain investigating authorities or certain other authorities have come in who are seeking a prior claim or attachment against those assets. The significant feature of Section 32 is that the immunity not only applies to assets of the corporate debtor taken over under a resolution plan under Section 31, but it also applies to assets of the corporate debtor which have been sold by a liquidator as part of liquidation estate of the corporate debtor, and some person has invested in those assets under the liquidation process. Now, this is also not a blanket immunity. If the assets transpire to the same management, the resolution plan is not envisaging a change of management and previous persons are only going to be under the management, this immunity shall not be available. If the investigating authorities specifically have any reason that yes, so and so person is claiming immunity under Section 32(2), however, this person has perpetrated the offence or has corroborated in the offence, and his presence or charges can be framed in the proceedings against such and such person basis on the material available on the record, that exception is carved out from the section, and that person can very well be continued to be prosecuted. Friends, when there is law, the compliance and adherence of the law is a matter of public policy, and if a immunity is brought in, it is seen as a protection being given to a certain persons for the offences which need to be prosecuted, which is seen by many in the public eye as an aberration to the public policy or strict compliance of the law. When Section 32A was introduced, it also met with similar challenges. The very constitutional validity of Section 32A was brought into question by way of a writ petition before the Honorable Supreme Court. The basic contention was that if there is law, there are certain compliances to be made, there are certain offences which have been perpetrated. Those should be brought to the logical conclusion by way of punishment. Otherwise, it will bring in leeways and mechanisms to non-compliance, and law will not be followed in its strictest sense. However, in this case, Manish Kumar versus Union of India, the apex court has diligently gone behind the objective of the parliament behind bringing the Section 32A, which is deepening the distressed investment market in India, bringing in more resolution applicants, so that there is larger number of resolution applicants taking interest for a particular distressed corporate debtor or its assets, being assured that they will not be falling into trap of legacy liabilities nor in trap of legacy proceedings. The assets that they are investing will be protected by immunity provided under law. And what this will help in maximization of value by increasing the competition in the marketplace. So the Supreme Court rightly observed the objective sought to be achieved, at the forefront of which is maximization of value of assets. This objective cannot become the subject of judicial veto on the ground of violation of Article 14. So the apex court upheld that Section 32A has been brought with a certain objective. That objective is very well aligned to the public policy, which is creating a deeper market for distressed assets, for early resolution, for maximization of value, and therefore it does not violate constitution. The law has been tested, and enforcement agencies, as they would have shown reluctance to let go of their investigative powers against the resolution applicants. There have been proceedings wherein the courts have sought from investigating agencies as to their take on why they should continue, and the investigating proceedings should be continued against the uh, persons whom they are claiming that the investigating proceedings should be continued, being the new management. The investigating authorities, the ED in this case, had a very generic response that as of now they cannot give a clean chit to the new management. They cannot not sure whether these persons will be required to be prosecuted or they have any role here, and accordingly the prosecution should be allowed to be continued. But NCLAT said no. If you have any reason to believe, if there are any reasons, you bring it on record. Otherwise, the new management will be exempted, and accordingly, exemption was granted. In another case, Tata Steel BSL Limited, the cogurance of Section 32A was very well taken by the adjudicating authority, being the Delhi High Court in this case, and they acknowledged that there is a resolution plan approved by adjudicating authority in place, so no prior proceedings for offences can be continued, and thereby discharge the corporate debtor of all the proceedings. Since the jurisprudence is developing, there is one case law, interesting case law, in case of Varsana Ispat, which has come in context of liquidation proceedings. In this, the NCLT has clearly adjudicated that even in case of liquidation, even if there is some asset which has of the corporate debtor which has been subject matter of any attachment, liquidator can very well sell that asset, and once it is sold under the liquidation process, the successful purchaser of the asset will get that free of the attachment, free of all encumbrances. So friends, you would have seen that Section 32A provisions and the immunity provided by them for the bona fide resolution applicants, not for the persons who were party to committing the offence, not for the persons whom can be believed to be the offenders in the original place, and whom the investigating authorities have reason to believe that basis on some material that they need to be prosecuted. This has deepened the distressed asset market by bringing in more and more resolution applicants, by giving them confidence that legacy issues will be legacy issues and they can have a clean and fresh start, and therefore they can be rest assured about their investment. Thank you, friends. That was all that I wanted to share with you on Section 32A of IBC. Thank you very much.
A warm welcome to IGNOU. If you are creative, if you can write well, and if you can visualize, mass communication is the correct career option for you. I am going to talk about postgraduate diploma in journalism and mass communication, which is also the first year of MA program in journalism and mass communication. So any learner who has done a postgraduate diploma in journalism and mass communication is eligible to take admission straight away into the second year of our master's program in journalism and mass communication. Duration to complete this program is minimum 1 year, and because we have this inherent flexibility in distance education system, you can take up to 3 years to complete this program. The minimum eligibility criteria for taking admission in this program is bachelor's in any discipline. To give you a glimpse of what are the various components of this program, we begin with telling you what mass communication is, what are the various areas, various branches of mass communication. Then we go on to tell you about the various reporting techniques and beats of reporting, followed by media ethics, the principles, the codes of conduct that you must follow, and we also focus on the writing skills and editing skills for print media. Now this program comprises of 8 courses of 4 credits each. 25% of the entire program is practical based. So we have 6 theory courses and 2 practical courses. This program is so designed so that it will be able to make you more employable in the market. So it helps you build a career in print media, in radio, television, new media, as well as the allied subjects of mass communication, which could be media marketing, advertising, public relations and corporate communications, event management. This can also help you become an entrepreneur in areas like photography or having your own production house and so on. So I hope that you will be excited to join this program, and we will be waiting to welcome you here in IGNOU.
Namaskar. I, Deeptanshu Singh, on behalf of Insolvency and Bankruptcy Board of India, welcome our esteemed viewers on today's session on role of state agencies under Insolvency and Bankruptcy Code 2016. So basically, the session has been divided into 2 parts. The first part, dealing with the role of state agencies under corporate insolvency resolution process, shall be covered by Shri Deepak Rao. He is an Indian Economic Services Officer and currently posted in Insolvency and Bankruptcy Board of India on the post of General Manager. The second part, covering the role of the state agencies during the liquidation process, shall be covered by me. So without dealing any much further, I invite Shri Deepak Rao to kindly start the session with his skills for the benefit of our esteemed viewers. Over to you, sir.
Thank you, Deeptanshu. A very warm welcome to all our viewers. Before understanding the role of state agency in insolvency and bankruptcy code, we need to understand the difference between the current regime and the earlier regime. Insolvency and Bankruptcy Code, basically it was enacted in 2006, and it has the core objective of resolving the insolvency matters in a time-bound manner. That is the first objective. And the second objective is that the value of the assets which enter into insolvency process should be maximized. Now generally what we have seen is that government's involvement is restricted as an operational dues. Generally the dues of the government are operational dues or operational it's operational dues, and then I'm not saying that always government dues are operational dues. Generally, they are operational dues, but there can be a few government dues which can be classified as financial dues also. Now, the code has a clear-cut waterfall mechanism, a clear-cut defined mechanism which is known as the waterfall mechanism, which fixes the priority of the various dues. Under this waterfall mechanism, the government dues are kept below the claims of the unsecured financial creditors. Now, earlier we had a model where if a person took loan from the bank and he becomes insolvent, still he had the control over the unit. Now we have shifted from the debtor in possession to creditor in control. The shift has given control to the creditors. Now debtor is no longer in possession under the new regime. Now the most important thing about the new code is that it has primacy over all other laws, and it has been confirmed by the Supreme Court in two of its prominent rulings. Supreme Court ने अपनी दो rulings में ये कहा है. पहली ruling जो है वो है Innovative Industries Limited versus ICICI बैंक, जिसमें सुप्रीम कोर्ट ने ये कहा है कि ये जो कानून है IBC, इसकी प्राइमेसी है जो स्टेट गवर्नमेंट के बने हुए कानून हैं उनके ऊपर. और जो दूसरी रूलिंग जिसका मैं जिक्र करूंगा वो है प्रिंसिपल कमिश्नर ऑफ इनकम टैक्स वर्सेस मोनेट इस्पात एंड एनर्जी लिमिटेड. इसमें यह कहा गया है कि ये जो कानून है IBC, इट हैज़ प्राइमेसी ओवर द इनकम टैक्स एक्ट ऑफ 1961. नेक्स्ट स्लाइड प्लीज. Now, state agencies का रोल यदि हम देखते हैं, state agencies under IBC, generally the state agencies are operational creditors. The code balances the interest of all the stakeholders and including the government agencies. When I've said all the stakeholders, government agencies are also a stakeholder in this entire process, except in very few cases. Companies under CIRP, when they enter into the CIRP process, they have dues such as GSTs, IT payables and all. In addition to that, they might also have dues which are to be paid to the agencies which supply the essential services such as water supplying agencies and electricity supply agency and all. So the agencies which primarily deal with these issues have to keep in mind that they are the important stakeholders or significant stakeholders in the entire process. तो ऐसी सारी सरकारी एजेंसियां जो टैक्स में डील करती हैं, चाहे वो इनकम टैक्स हो, GST हो, सेल्स टैक्स हो, या फिर वो सरकारी एजेंसियां जो बिजली की सप्लाई करती हैं, पानी की सप्लाई करती हैं, तो ये सारी एजेंसियों को ये समझना होगा कि वो इस पूरे प्रोसेस में बहुत इंपॉर्टेंट स्टेक होल्डर हैं. और एक महत्वपूर्ण पहलू ये है कि ये जो IBC 2006 है वो इसके पहले जो भी एक्ट इस विषय से संबंधित थे उससे अलग है. इसमें सरकारी जो महकमे हैं उनमें उनका रोल जो है वो अलग है. यदि आप कंपनीज एक्ट देखें, चाहे वो 1956 का हो, 2013 का हो, या इनकम टैक्स एक्ट जो है 1961 का हो, उन तीनों के मुकाबले जो है इसमें सरकारी महकमों की भूमिका जो है वो अलग है. नाउ, in order to understand the role of the government agencies in IBC, we need to understand the process of IBC. वो प्रोसेस कहाँ से शुरू होता है? प्रोसेस की शुरुआत होती है इंसॉल्वेंसी रेजोल्यूशन प्रोसेस से. जब एक कंपनी इंसॉल्व होती है, इंसॉल्वेंट होती है, तो उसके बाद सबसे पहला जो स्टेप होता है, द फर्स्ट स्टेप इज़ अपॉइंटमेंट ऑफ IRP, इंटरिम रेजोल्यूशन प्रोफेशनल. वो इंटरिम रेजोल्यूशन प्रोफेशनल जो है वो एक नई शुरुआत करता है. ऑल्दो इट माइट लुक दैट इट्स अ स्टॉप गैप अरेंजमेंट, बट ही इज़ द मोस्ट इम्पॉर्टेंट pillar in this entire process because he has to take up the role of the erstwhile मैनेजमेंट इन द कॉर्पोरेट डेटर. एक तो वो कॉर्पोरेट डेटर से अपने पास मैनेजमेंट का काम लेता है. दूसरा ये है कि इट हैज़ टू प्ले एन इम्पॉर्टेंट रोल वाइल कीपिंग द यूनिट अलाइव. उसके जो एसेट्स हैं उसको, उसका वैल्यू जो है उसको मैक्सिमाइज करना रहता है उन्हें. उसके अलावा जो है उसको एक रनिंग कंसर्न के तौर पे उसको चलाना होता है. तो डेट्स वाई जब एक IRP अपॉइंट होता है तो IRP के अपॉइंटमेंट के साथ एक नया रेजीम शुरू होता है, एक नया दौर शुरू होता है. तो वो सारे सरकारी महकमे, ऑल दोज गवर्नमेंट डिपार्टमेंट्स, इट कुड बी स्टेट गवर्नमेंट एजेंसीज, इट कुड बी सेंट्रल गवर्नमेंट एजेंसीज एंड ऑल, हैज़ टू कीप इट इन माइंड दैट एन इंसॉल्वेंट प्रोफेशनल, an IRP or an RP, either it could be interim resolution professional or he could be a resolution professional. He is a professional appointed by a court of law. So they need to extend all possible cooperation to that person who is working as either IRP or RP to resolve the case. And then because his objective is to revive the unit for the larger interest of the economy. Now, what is moratorium? We have been hearing of a term moratorium when we discuss IBC. Moratorium क्या होता है और IBC में उसकी क्या भूमिका है? Moratorium is the period which starts with the commencement of the insolvency process. A company becomes insolvent. Once it becomes insolvent, the control of the regime is passed on to an IRP. Once an IRP becomes a management of the company, all the previous dues and all the previous acts of the company becomes an history. So once the moratorium period starts, once the CIRP process is initiated, in that case, no suits or proceedings can be initiated or continued against the corporate debtor. तो जब एक बार CIRP की प्रक्रिया शुरू हो जाती है तो उस केस में ये है कि सारी गवर्नमेंट एजेंसीज को ये बात ध्यान में रखनी चाहिए कि जो पुराना डेप्टर है, पुराना कॉर्पोरेट डेप्टर है, जो अब तक मैनेजमेंट हुआ करता था, उसकी भूमिका खत्म हो गई है. अब नया कॉर्पोरेट डेप्टर आया है, उसकी भूमिका शुरू हुई है. तो जो पुराने केसेस हैं वो उसके अगेंस्ट में, अब नए डेप्टर के अगेंस्ट में, नया जो मैनेजमेंट है उसके अगेंस्ट में आप शुरू नहीं कर सकते. देन नो पनिटिव एक्शन कैन बी taken by any government authority. Here the government authority could be income tax, सर्विसेज टैक्स, इन्फोर्समेंट डायरेक्टरेट एक्सेट्रा. अब इसमें एक बहुत महत्वपूर्ण जो है वो निर्णय है सुप्रीम कोर्ट का, एन इम्पॉर्टेंट रूलिंग ऑफ द सुप्रीम कोर्ट विच सेज दैट कि उसमें एक महाडा और राजेंद्र कुमार भट्टा का केस था जिसमें जो है महाराष्ट्र अर्बन डेवलपमेंट अथॉरिटी थी जिसने लीज लैंड दिया हुआ था एक सीडी को, और उसके बाद जब वो इंसॉल्वेंट हो गया तो उन्होंने वो लीज लैंड वापस लेने की बात की. तो सुप्रीम कोर्ट ने ये कहा कि साहब ये संभव नहीं है, क्योंकि आप जब जो है कॉर्पोरेट डेटर के अगेंस्ट में जो भी आपको इनिशिएटिव लेना था, जो भी केसेस इनिशिएट करने थे, वो उस दायरे में करने थे कि जब तक CIRP शुरू नहीं हुआ. एक बार CIRP शुरू हो गया तो आप ये नहीं कर सकते. तो ऑल दोज गवर्नमेंट डिपार्टमेंट्स which deal with such issues should always keep this particular ruling of the Supreme Court in mind. And then when it comes to moratorium, another issue is any license, quota, permit, registration granted by any authority to the corporate debtor cannot be terminated only on the grounds of insolvency. जब आप कोई लाइसेंस जारी करते हो, आप कोई कोटा जारी करते हो, आप कोई परमिट जारी करते हो या रजिस्ट्रेशन जारी करते हो, साधारणतः होता ये चीज़ है कि ये सारी चीज़ें, चाहे वो कोटा हो, चाहे वो रजिस्ट्रेशन हो, चाहे वो परमिट हो, सरकारी महकमों द्वारा जारी किया जाता है. दीज आर इशूड बाय द गवर्नमेंट एजेंसीज. सो वंस यू ग्रांट दीज थिंग्स इट कैन नॉट बी विदड्रॉन ओनली ऑन द ग्राउंड्स ऑफ कॉर्पोरेट इंसॉल्वेंसी. बाकी बहुत सारे ग्राउंड्स होंगे तो आप विड्रॉ कर सकते हैं, बट कॉर्पोरेट इंसॉल्वेंसी के अकेले ग्राउंड के आधार पे आप विड्रॉ नहीं कर सकते. और दिस हैज ऑल्सो बीन कन्फर्म्ड by NCLT in the case of Aircel Limited and Dishnet Wireless Limited. इस केस में ये हुआ था कि एयरसेल लिमिटेड जो है वो टेलीकम्युनिकेशन के बिजनेस में था और उस बिजनेस में उसे एक लाइसेंस दिया गया था. जब कॉर्पोरेट इंसॉल्वेंसी की प्रोसेस शुरू हुई तो उस लाइसेंस को विड्रॉ करने की बात हुई. तो उस केस में NCLT ने ये कहा कि इस बिज़नेस का आधार जो है वही लाइसेंस है, तो यदि आप लाइसेंस विड्रॉ कर लोगे यहाँ पर तो इसमें रेजोल्यूशन प्रोसेस जो है उस पर ही पाबंदी, उस पर ही समस्या उत्पन्न हो जाएगी. तो it was essential for getting a good resolution plan. So NCLT said it cannot be done. So all those government agencies which issue licenses, which issues permit and all, should always keep this particular judgment in mind while taking decisions, while handling the IBC cases. And then critical services cannot be terminated. What do you mean by critical services? Critical services are all those services which are essential for running of a unit. It could be a manufacturing unit or service sector unit. यहाँ हम ये कह सकते हैं कि जो बिजली की आपूर्ति है या पानी की आपूर्ति है उसको क्रिटिकल सर्विसेज में क्लासिफाई किया जा सकता है. एक केस था दक्षिण गुजरात विज कंपनी वर्सेस ABG शिपयार्ड लिमिटेड. इस पर्टिकुलर केस में जो अपीलेट ट्रिब्यूनल था उसने ये बोला एसेंशियल गुड्स एंड सर्विसेज टू कॉर्पोरेट डेप्टर शुड नॉट बी डिसकंटिन्यूड. अब यहाँ एक here one particular point which I would like to stress upon is that you need to distinguish or differentiate between the current debts and the past debts. यदि कोई यूनिट इंसॉल्वेंट हो जाता है और वो ऑनगोइंग कंसर्न है और अभी वर्तमान में जो बिजली के बिल हैं, जो पानी के बिल हैं, यदि वो नहीं दे पाते हैं तो उनको आप दूसरी तरीके से देखिए. लेकिन जो पुराने डेट्स हैं that need to be seen from a different perspective, and this particular judgment is about that only. इसमें ये कतई ना समझा जाए, one should not draw the inference from this particular ruling that even the ongoing concern should not pay its bills for the supply of essential services. It's not like that. Now claim submission is another issue which is very important. Claim submission, After initiation of insolvency process, claims be submitted to interim resolution professional. Claims जो है सबसे इम्पॉर्टेंट चीज़ होती है, क्योंकि यहाँ पर जो है सरकारी महकमे जो है ऑपरेशनल क्रेडिटर्स हैं, इनको अपना क्लेम सबमिट करना पड़ता है. क्लेम सबमिशन बाय गवर्नमेंट अथॉरिटीज़ इन द प्रिस्क्राइब टाइम लिमिट. इस पूरे प्रोसेस की सबसे महत्वपूर्ण तथ्य ये है, इस पूरे प्रोसेस का सबसे महत्वपूर्ण बिंदु ये है कि ट्राइज टू रिजॉल्व द इंसॉल्वेंसी इन ए टाइम बाउंड मैनर. जब हम टाइम बाउंड मैनर की बात करते हैं तो हर एक प्रोसेस के लिए एक टाइम निर्धारित है. देयर इज अ टाइम फ्रेम प्रिस्क्राइब्ड फॉर एवरी प्रोसेस. नाउ गवर्नमेंट agencies which are operational creditors need to file claims in a prescribed time limit, and non-submission of claim leads to loss to exchequer. Now non-submission of claims कैसे loss to exchequer की बात करते हैं वहाँ पर हम, क्योंकि ये क्लेम्स जो हैं वो सरकारी आमदनी हो सकती थी. यदि आप टाइम पे फाइल करते इसको तो ये आपके खाते में आते हैं. इफ़ यू मिस द टाइम लिमिट देन यू हैव मिस द बस, देन यू आर नो लॉन्गर इन द पिक्चर. तो आप यहाँ से अलग हो जाते हैं. यहाँ पर इस पे घनश्याम मिश्रा वर्सेस एडलवाइस एसेट रिकंस्ट्रक्शन कंपनी का एक इम्पॉर्टेंट केस है, जिसमें ऑनरेबल सुप्रीम कोर्ट ने ये कहा है कि ऑन द डेट ऑफ अप्रूवल ऑफ रेजोल्यूशन प्लान, जिस दिन रेजोल्यूशन प्लान अप्रूव होता है उस दिन यदि क्लेम्स जो है रेजोल्यूशन प्लान का हिस्सा नहीं है तो वो रेजोल्यूशन प्लान से बाहर है. दे शैल स्टैंड एक्सटिंग्विश्ड एंड नो पर्सन विल बी इंटाइटल्ड टू इनिशिएट और कंटिन्यू एनी प्रोसीडिंग्स इन रिस्पेक्ट टू अ क्लेम विच इज़ नॉट ए पार्ट ऑफ रेजोल्यूशन प्लान. अगर हम रेजोल्यूशन प्लान की बात करें तो सेक्शन 31 ऑफ द कोड जो है वो ये कहता है कि एक बार रेजोल्यूशन प्लान, वंस द रेजोल्यूशन प्लान इज अप्रूव्ड बाय एनसीएलटी, इज बाइंडिंग ऑन ऑल डिपार्टमेंट्स इंक्लूडिंग सेंट्रल गवर्नमेंट डिपार्टमेंट्स एंड स्टेट गवर्नमेंट डिपार्टमेंट एंड एनी लोकल अथॉरिटी ऑल्सो. तो हमारी अर्बन अथॉरिटीज़ और म्यूनिसिपल अथॉरिटीज़ जो हैं दे शुड ऑल्सो अंडरस्टैंड दैट वंस द रेजोल्यूशन प्लान इज अप्रूव्ड बाय एनसीएलटी इट इज़ एप्लीकेबल एंड इट इज़ बेसिकली बाइंडिंग ऑन ऑल. दूसरा ये है कि अल्ट्राटेक नाथद्वारा सीमेंट वर्सेस यूनियन ऑफ इंडिया एक इम्पॉर्टेंट कोर्ट केस था, जिसमें जो एडजुडिकेटिंग अथॉरिटी है उसने ये बोला था कि वंस द अप्रूवल ऑफ द रेजोल्यूशन प्लान इज डन, नो फ्रेश डिमांड नोटिस कैन बी इश्यूड बाय सेंट्रल गुड्स एंड सर्विसेज टैक्स. हालांकि ये पर्टिकुलर जो है ऑर्डर जीएसटी के डिपार्टमेंट के लिए था, बट इट्स इक्वली एप्लीकेबल टू ऑल टैक्स डिपार्टमेंट्स. नाउ रेजोल्यूशन ऑफ कॉर्पोरेट डेटर की जब हम बात करें, सेक्शन 32A, लायबिलिटी ऑफ अ कॉर्पोरेट डेटर फॉर एन ऑफेंस कमिटेड प्रायर टू कमेंसमेंट ऑफ CIRP. यहाँ पर ये देखेंगे कि यदि एक कॉर्पोरेट डेटर कोई ऑफेंस करता है CIRP की प्रक्रिया शुरू होने के पहले, तो वो पास्ट है, वो हिस्ट्री है. उसके बाद जब नया सक्सेसफुल रेजोल्यूशन एप्लीकेंट आता है तो सक्सेसफुल रेजोल्यूशन एप्लीकेंट के आने के बाद उसके विरुद्ध जो पुरानी CIRP, पुराना जो कॉर्पोरेट डेटर है उसके द्वारा जो ऑफेंस किए गए हैं उसके लिए कानूनी कार्रवाई नहीं की जा सकती. यहाँ पर इफ़ द रेजोल्यूशन प्लान रिजल्ट्स इन द चेंज ऑफ मैनेजमेंट देन द न्यू रेजोल्यूशन एप्लीकेंट विल नॉट बी लायबल फॉर द एक्ट्स कमिटेड बाय द अर्स्टवाइल कॉर्पोरेट डेटर. इस केस में टाटा स्टील वर्सेस यूनियन ऑफ इंडिया में हाई कोर्ट ने एक बहुत अच्छी रूलिंग दी है. ऑनरेबल हाई कोर्ट हेल्ड दैट CD वुड नॉट बी लायबल for any offence committed prior to commencement of CIRP. It is also certified that such an order will not affect the prosecution of the erstwhile promoters or any officer who may be responsible for committing the offences. So the यहाँ clarification भी है कि यदि एक इस तरह की चीज़ें होती हैं तो जो पुराना offences है तो उन पुराने ऑफेंसेस के प्रोसिक्यूशन जो है और उसके लिए जो जिम्मेदार जो हैं उसके ऊपर कोई असर नहीं पड़ेगा इसका. तो जो नए रेजोल्यूशन एप्लीकेंट हैं उनको आप छोड़ देंगे और जो पुराने लोग हैं जो जिम्मेदार हैं इन ऑफेंसेस के लिए उनको, उनके ऊपर जो प्रक्रिया है वो जारी रहेगी. तो ये था जो पहला हिस्सा है रेजोल्यूशन प्लान का. नाउ माय कलीग दीप्तांशु विल फोकस ऑन द सेकंड पार्ट, दैट इज बेसिकली द लिक्विडेशन. ओवर टू यू दीप्तांशु.
Thank you, sir. Thank you so much. So it was indeed a very insightful expression of the role of state agencies during the corporate insolvency resolution process. So moving forward, we will go through the role of state agencies during the liquidation process under the Insolvency and Bankruptcy Code. So the liquidation process, it commences on the failure of the corporate insolvency resolution process to provide a resolution plan. The resolution professional who was appointed for the corporate insolvency resolution process, he typically acts as the liquidator for the purpose of liquidation. And the duties and powers of liquidator is that he invites the claims and verifies them. He takes the control and custody of the assets of the corporate debtor. He then goes on for auctioning the assets of the corporate debtor, and ultimately he distributes the sales proceed in accordance with section 53 of the code that provides for the waterfall mechanism. Also, the personnel of the corporate debtor, he has to extend all cooperation to the liquidator in performance of his duties. So, the state agencies, whether the administrative agencies or the law enforcement agencies, they must keep in mind that they have to support the liquidator in performing his duties. So, once a liquidation process is initiated, the submission of claims has to be done. The claims are submitted to the liquidator. The government authorities who have any claim against the corporate debtor, they have to submit their claim in the prescribed time limit. And as very well explained by my colleague Shri Deepak Rao ji, that the non-submission of claim, that would lead to the loss of exchequer. In one case also, the Leo Edibles and Fats Limited versus the Tax Recovery Officer, Income Tax Department, Hyderabad and others, the High Court of Telangana and Andhra Pradesh, it held that the Income Tax Department necessarily submit its claim to the liquidator for consideration as and when the distribution of the assets in terms of section 53(1) of the code is taken up. And it also stated that the priority which has been provided in the waterfall mechanism under section 53 of the code, it cannot be disturbed. So the whole process for the corporate insolvency resolution and thereafter the liquidation process, it's a time bound mechanism. The time bound mechanism helps to reduce any further erosion in the value of the assets. So it's very important that the government agencies or any other person who have any claim against that corporate debtor, he has to submit that claim in the prescribed time limit. Further, under section 53, wherein the waterfall mechanism has been provided, the waterfall mechanism I refer to the priority in which the payments to various creditors can be given. The government, they have reduced their priority even below the unsecured financial creditors. Why they have done so? Just to give market a boost. So government has here taken a back step to give market the boost. But yes, the claims have to be submitted by the government in a time bound mechanism so that the whole liquidation process is completed timely. Further, as we have seen in the case of corporate insolvency resolution process, the moratorium, which was started during the corporate insolvency resolution process, it ceases when an order of the liquidation of the corporate debtor is passed. But during liquidation period also, a certain moratorium is applied wherein no suit or any other legal proceedings can be instituted by or against the corporate debtor except by the liquidator himself on behalf of the corporate debtor with the prior approval of the adjudicating authority. So this silent period under moratorium is provided so that there is a calm period for the liquidator, and in the case of the corporate insolvency resolution process, the IRP or RP, to very smoothly go on the process of insolvency resolution, and in the case of liquidation, the liquidation process. Okay, so the most important thing in the liquidation process is the sale of assets. As we have seen during the corporate insolvency resolution process, once the CIRP is completed, the resolution plan is approved, section 32A comes into force, which says that any criminal action which is pending before the corporate debtor, which was instituted against the corporate debtor before the commencement of the insolvency resolution process, it will cease to have effect. This is also applicable in the case of liquidation process. So once the liquidation commences, the sale of assets is going on. So just imagine a scenario wherein the liquidator, he is going to sell an asset, any land or any plant and machinery, and the various government authorities or any law enforcement authorities, they stake their claim that this land, you cannot sell this land because it is attached by some law enforcement agencies or some any other authority. This will be very difficult for the corporate debtor to get dissolved. So it has been very well stated in the case of Anil Goel, the liquidator appointed in the respect of Varsana Ispat Limited, that the protection that has been provided under section 32A, it will also be available to sale of liquidation assets. A liquidator can proceed with the sale of the assets even if it is under attachment by the ED. So the point for consideration for the law enforcement agencies as the state government or the central government or any other local authority agencies is that once the liquidation is going on, the assets which have been attached, they have to be released for the benefit of the corporate debtor. So going through all this process of the corporate insolvency resolution process and the liquidation process, What are the key takeaways for the state government, central government, any other local authority, for any other government agencies? Is that the concerned government authorities, firstly, they must submit their claims in prescribed time limit, whether for the corporate insolvency resolution process or whether for the liquidation process. They should not institute or continue any proceedings against the corporate debtor during resolution or liquidation process, because moratorium comes into effect. A calm period is required to smoothen and expedite the process of insolvency resolution or liquidation of the corporate debtor. They should not discontinue essential services to the corporate debtor. Why is it so? Because the objective of the code is to maximize the value of the assets. That's why the time bound resolution of the corporate debtor is provided. To maximize the value of the assets, it's very important that during the corporate insolvency resolution process, the company is taken care of as a going concern. The activities, the operations of the company is not stopped. Once the operations of the company is stopped, the resolution plan, they will not fetch a good value for the corporate debtor. So it's very important that the essential services, that is very critical for the company to survive and to go on for their business, they should not be stopped. Further, any license, any registration, any quota, any permit that has been granted to the corporate debtor by the government agencies, they should not be stopped. The government agencies, they should be part of the insolvency resolution and liquidation process of the corporate debtor in accordance with the code. Also, the government agencies, they must support the IRP and IRP to fulfill their statutory duties under the code. One such example is that the police agencies, the police personnel, the law enforcement agencies, if the resolution professional or interim resolution professional, or for that matter the liquidator, if he approaches the police agencies to seek appropriate support from them, the police should, we say that they should provide appropriate support to the RP to perform his functions. Because once a company is not going, it is not a going concern, there are various difficulties, there are various problems which he is facing. Going further, the state agencies or the central government agencies, the agencies, they must allow the IRP or the RP to comply with the statutory obligations such as filing of tax, the goods and services tax or income tax, etc. They must release the attachments over the properties of the corporate debtor. They should not initiate or continue criminal proceedings against the corporate debtor. And they also facilitate the successful resolution applicant in getting necessary regulatory approvals for implementation of the resolution plan. And they also extend the police protection when required by the IRP, RP or the liquidator. So with this, we conclude today's session. And I thank you, Shri Deepak Raoji, for giving an insightful experience on the corporate insolvency resolution process. I hope that this session will be helpful to all, and particularly the government functions, the functionaries, to meet the objectives of the code, which is the value maximization of the assets and ultimately to promote the entrepreneurship in the economy. Thank you so much.
Thank you.
Are you a fresh graduate? Do you want to fulfill your educational aspiration by pursuing higher education in various interdisciplinary and multidisciplinary areas like environmental science, environment and occupational health, philosophy, sustainability science, folklore and culture studies? If yes, the School of Interdisciplinary and Transdisciplinary Studies offers various programs like Master's Program, Graduate Program, Postgraduate Diploma, Certificate and Appreciation Program. The school offers 5 Master's Program: Master of Science, Environmental Science. The eligibility criteria for MSc Environmental Science is Graduate in Science, BTech, BE, Agriculture Graduate, Forestry Graduate and Veterinary Graduate. School also offers
Masters in Environment and Occupational Health, Masters in Sustainability Science, Masters in Philosophy, and Masters in Folklore and Culture Studies. The eligibility criteria for these 4 master's programs is graduate in any discipline. The school also offers various socially relevant and need-based PG diploma programs like PG Diploma in Sustainability Science, PG Diploma in Environment and Occupational Health, PG Diploma in Folklore and Culture Studies, and PG Diploma in Migration and Diaspora Studies. The school also offers PG Certificate in Climate Change and Avshist Prabandhan mein Praman Patra. The school also offers 2 doctoral programs, PhD in Environmental Science and PhD in Interdisciplinary and Transdisciplinary Studies. The school offers various innovative technologies and multimedia for providing a very excellent student support system. The study material is of high quality. The learner support is provided through Gyan Darshan, Gyan Vani, IRC, Swayam Prabha and Swayam channel of IGNOU. For more detail, please log in to IGNOU website. For online admission in these programs, visit school site and also the Samarth online education portal of IGNOU. So please join these programs and fulfill your educational aspiration.
Welcome to the session on concepts related to nursing research. In this session, you will learn about basics, that is, why nursing research is required, what are the basic steps to follow by a researcher. This will give you an overall view how to conduct a nursing research. So let us see what is nursing research and why it is required by a nurse researcher. Nursing research is an essential component of professional advancement to provide evidence-based care to take decisions in administration and nursing institution. Various studies has emphasized that just teaching a nursing research as a subject is not enough unless the nurses who are working in the clinical area or an educational institution or are administrators carry out a nursing research. What is nursing research? Most of the literature emphasize that research is a systematic inquiry that uses disciplined methods to answer the questions and to solve the problems which nurses are facing in day-to-day clinical area, in community or in the educational institution or carry out the administrative responsibility. Nursing research is a systematic inquiry to develop an evidence to take a decision. New knowledge can be created, interventions can be experimented, and programs can be evaluated. There is a wider scope of conducting a nursing research. That is, answering the questions which you are not able to find any answer for it. Solve the problems, day-to-day problems. Improve health of the people. provide cost-effective care, reduce the mortality and morbidity, find out the causes, help in implementing preventive and the control measures, even to help in the finding out the incidence, prevalence, and handle the epidemics and pandemics. I think COVID-19 has taught us a lesson how far the research is going on and why it is important. What is evidence research practice? Evidence-based practice means to use the evidence in making decisions which have clinical evidence, which are cost-effective, and outcome of the patient is improved. For example, I think all of you know kangaroo care has shown evidence that skin-to-skin contact have clinical benefits, and actually it has the impact on the health of the newborn, and it is very important for the bonding of the mother and the child. Evidence is required for things that you have learned to practice. By giving an evidence, yes, it will be very effective, but many a times the evidence is given through experiences, traditions, trial and error, experts in the profession, but they are not scientifically proved. So sources of evidence are traditional and the authority. Certain beliefs are expected as truth and certain practices are effective over the time. Another source is authority, which is based on the expert knowledge, but they have their limitations, which are based on textbooks, experience rather than on evidence. Then there is a clinical experience or trial or error. You must have seen when you are working in a clinical area, many procedures or many decisions are taken because which are based on the experience or trial and error in some situation. But it again has a limitation because personal experience can have the bias and they cannot be implemented in all the situations. Assembled information. Many a times information is collected for various purposes and sometimes it is used to solve the problems, but the same information may not be useful in all the situations. Therefore, the disciplined research is a best reliable method for evidence as it is based on a scientific method. Paradigm of nursing research. Paradigm of nursing research is based on positivism and the constructivism. And four meta paradigms are nursing, health, environment, and the patient. If you see types of research which can be carried out, quantitative positivism and qualitative constructive inquiry. What is quantitative studies? You must have learned in your courses there are two types of studies, quantitative and qualitative. So quantitative research follows systematic way, following various steps which are pre-planned. Researchers gather empirical evidence using tools and instruments. Then they generalize the research findings to the population. Types of quantitative studies can be descriptive studies, observational studies, and analytical studies. You can see here types of descriptive studies are case report, case studies, cross-sectional studies, ecological studies. Observation studies, there is no exposure, there is a comparison group can be there. Analytical can be case control, cohort studies. Then experimental and the quasi-experimental. True experimental studies has exposure, intervention, control, and randomization. But quasi-experimental studies have intervention but non-randomized and there will be no control is there. Qualitative studies. Nowadays, the qualitative studies are parallel used or a mixed method is used for the research. Qualitative studies focus on human experiences as it is lived through collection and analysis of qualitative information that is narrative, subjective, in-depth, real life experiences. There is flexibility during data collection because the analysis and data collection go together in qualitative studies till the time data is saturated. Like there are examples, ethnographic studies, description and interpretation of culture and cultural behavior, that is where the people live. There is extensive field work. Many researchers go and live in the communities and actually observe how people live, what are their culture, traditions. So that is ethnographic. Phenomenological studies study life experiences of people, give meaning to each person's perception and their phenomena which they go through. Grounded theory, this is a basic which contributes to theories in nursing. This is purely a basic research is being done in that. And nowadays, narrative analysis is also very common. Individual makes sense to the events in their lives and narrate the stories. So again, you can see how intensive and in-depth these qualitative studies will be. Some of the steps of qualitative studies. Identify the broad area or a problem. In these, samples will be small because these studies are in-depth. Convenience, snowball sampling or purposive sampling is selected in qualitative studies. Select research site for information. Already I have told you the researchers goes to the community and live with the people or observe them minutely. Design of study evolved during the process. Merging data, that is triangulation, is done through participative observation, focus group discussion, in-depth interviews, records, photographs, diaries. Participants express their beliefs, feelings and the researcher observe and record them but with their permission, with their consent. Researcher asks question till data is saturated. It's very important to remember in qualitative studies. Qualitative studies, then when you do the analysis, then it is very important to do coding and the content analysis. While doing a coded, the themes and the sub-themes or the patterns are identified. Then they are being analyzed. Field, reflective and the personal notes by the researcher are referred here. So whenever the researcher goes in the field, they have to very carefully note down the observation. Researcher validate and review the themes, then they analyze. Now let us see, most commonly the qualitative studies are now they have recently been started, but quantitative studies are very common. So let us see the phases of quantitative studies. Identify the broad research area, narrow down and formulate statement of problem. Review of literature is done before also and after you formulate. It is every step one has to do a review. Conceptual framework is selected or researcher design their own conceptual framework and operational definition of terms are given. Operational definition of terms are not dictionary meaning. They are the meaning to the terms independent and dependent variables and other variables what researcher is giving in their research. Then research questions are formulated and in case hypothesis is required, hypothesis is also formulated. What are the sources of health problems? There are various sources. It can be through your experience. It can be the need of the hospital. It can be through review of literature. It can be to solve any problem. It can be through nursing theories and models. Other sources can be through sponsors, funders, or university has some interest in that particular area. Journal review, conferences you can say the presentations or recommendations by previous researchers, or there can be various other ways to find out a research problem. Specify the problem, or you should select a problem which is researchable, which has relevance to the health system or the institution where you are working, which is ethical, feasible to do in terms of time and the cost, and contribute to knowledge and practice. So your research problem should have, it can be PICO, PO or PICOS, that is your population, intervention, comparison group and outcome, or the problem statement will have population, intervention and outcome, or it will have all the 5 components depending on the problem and the objectives what you have selected: population or patients, intervention or exposure, outcome, comparison group and setting. Research hypothesis. Hypothesis is prediction. What the researcher is predicting about the study. Descriptive study will not have hypothesis, but analytic study will have a hypothesis. Research hypothesis is a prediction of relationship between independent and dependent variable. You can see an example. Older patients are more likely to fall than younger patients, or it can be older patients differ from younger ones with respect to risk of falling. Next is null hypothesis. It states there is no relationship between independent and dependent variable. Same example we can write as a null hypothesis is older patients are just as likely as younger patients to fall. So in case you have hypothesis, you have to write your research and null hypothesis both. Now review of literature and definition of terms. It is very important to identify the key terms to search the studies in the database. It can be PubMed, it can be Medline, it can be various other sources. So your keyword should be matching with the mesh terms which are given in the PubMed, so that you can find the related studies related to your topic, which will help you to identify what is already being done, what was the research methodology being adopted, research design, sampling process, what were the analysis and findings, recommendations and implications of that study. You can search all the relevant published and the unpublished data, conference findings, books, journals. You can go to various platforms and find out, even to go to the libraries to search online and the offline sources. Organize the findings and make a summary of it. Date-wise, it's very important. Otherwise, sometimes you forget to write it. Second phase is design and planning. Your methodology part will come. Selecting the research design, appropriate research design with your justification should be given. Develop intervention or protocol if any. Identify the population, design sampling plan and sample size, methods to measure the variables, your research ethics to safeguard the subjects, review and finalize your research proposal or your research plan. Your research design, already I have told you, it can be experimental, where intervention will be there, control group will be there, randomization will be done, details of intervention you have to give in methodology, who will implement, when, where, how many times, what will be the interval between the intervention, and how long that intervention will be implemented, and what will be the risk and the benefits. Beforehand only you have to identify. Quasi-experimental, you can be intervention control group. In some studies, there may be control group, there may not be control group in quasi-experimental groups. And no randomization is done in quasi-experimental. Non-experimental studies, your observation studies, finding association or relationship between variables and interventions. Now, what is population and sample? Population means all the individuals with common characteristics as per the criteria. Suppose you want to do a study on all the pregnant women. So, all the pregnant women in that particular area or community will be your population. Accessible population will be who are accessible for your research. Sample from that accessible population, you will select a sample. With the sampling technique you want to follow, probability or a non-probability sampling technique. Sample is selection of part of population for your study, and sampling plan is how many samples will be selected. So there are two methods: probability sampling, non-probability sampling. In probability sampling, random selection from a population is done. Each member has equal chance of selection. It can be simple, stratified or systematic or a cluster sampling, where if you select one member, the person has to again go back to that group. But again, if by chance they are being selected, they will not be written as participant, but they will go back in the groups. Just example, like a lottery system. Suppose you have to select 100 participants. You will make 100 slips. Suppose slip number 10 is selected, 15 is selected. Then randomly you go on selecting. Again the slip number 10 will come. But you will not write again, but you will keep it back, the slip in that bowl, so that everyone has an equal chance. Non-probability sampling can be your convenient sampling, quota sampling, your purposive sampling, where randomization is not done and the members do not have the equal chance to be selected. Like you have gone to a remote area where you want to do some study on your maybe on the psychiatric problems, schizophrenic patients. Maybe that selected people are available there. So what you will do, it can be a snowball. It can be conveniently, when you come to know, go through the data and conveniently you select. Maybe in the house number 1 there is one patient, maybe in house number 50 there is another patient. So selectively you are selecting, conveniently or purposefully. Suppose you have selected one school purposefully due to your convenience, due to time shortage or due to the permission which is being given. There can be many reasons, but you have to justify the reason why you are selecting conveniently or purposefully, or it is a random selection. Sample size, very important. Sample size, there is a formula to calculate the sample size according to your population, according to your study, according to your time, but it is being said larger the sample, there will be less sampling error, and if it is a quantitative study, the generalizations can be done easily. But again, you have to see the cost, time and the resources available, and many a times you can even take the help of a statistician suppose you face any problem. Methods to measure the variables. It's very important to do a data analysis once you have collected the data. But how to collect a data? Measurement involves assigning numbers to objects or people and designate quantity to an attitude. So there are 4 levels of measurement. Nominal, that is, number is given or to categorize an attribute like gender. Male is given 1 or female is given 2. Second is ordinal. Rank people like ability to perform activities, like in the school we do ranking, first, second, third, fourth. Same way ranking can be done. Interval, rank attribute and find distance between, like in IQ test. Ratio has a meaningful meaningful 0. Methods of data collection. They can be collected through primary source or secondary source. Secondary sources, you do a review, text review in the libraries of old studies, journals, and come out with the data or information what is required related to your study. Primary, you design a tool yourself or you adopt a standardized tool. Some tools are freely available which are standardized. For some, you have to take the permission. When you make your own tools, it can be interview guide, focus group discussion, or a discussion guide, interview guide, observation checklist, rating scale, attitude scale accordingly to your study. But again, it has to be, their reliability and validity needs to be calculated and see that your tool is reliable and to validate. What is reliability and validity now? Reliability means a consistency in which an instrument measures attribute, that is accuracy of instrument is being seen. That is, suppose you are measuring a weight of a person. Every time you should be able to measure the weight. Validity is degree to which it measures what is supposed to measure. If weighing machine is not giving you accurate measurement or a pain measurement scale you want to use it, then it should be able to measure the pain or the weight whatever instrument you are using. Reliable means every time you get a reliable reading from that instrument. Then ethical considerations, very important part. In the health sector, we follow the ICMR guidelines. The latest guidelines of ICMR are available at their website, 2017 guidelines, and Institutional Ethical Review Board approval for any study done in the health sector by anyone. So some of the ethical considerations, basically 4 basic principles are autonomy, beneficence, malbeneficence, and the justice. Autonomy, voluntary decision to participate. Benefit to all, beneficence. Malbeneficence is do not harm. Justice, equal distribution of the benefit to the people after the study. Minimize or prevent harm to the participants, and it is very important in the beginning in your informed consent it should be written that there will be these benefits and risks are there. In case they have any side effects, the researcher is responsible to give the treatment cost and get the person treated. And participants who have the right to leave the study anytime in between, no one can force any participants to participate in study. And selection of subjects is an ethical concern. Do not select people who are very vulnerable, who can have no say in decision making. Informed consent, people who are illiterate or not able to give the informed consent, there has to be a witness who will sign for them, or there will be a legally authorized person who will sign on their behalf. Even the informed consent, if any care is required or the person becomes sick during research, it is the responsibility of the researcher. Collecting the data, this is pre-planned. Who will collect, when, where, how much time will be spent, how recording will be done, or how confidentiality will be maintained. Prepare data sheets, table for analysis, coding is done, and even the confidentiality and privacy of the data to be maintained very accurately even nowadays with the computers. Data analysis is, you have to use a descriptive statistics or inferential statistics. Interpretation of the results is to be given, then discussion is to be carried out in detail, giving reference of previous studies. Then the last phase is dissemination and communication of your research findings to your organization, writing a report and submitting, publication of your articles with the ethical considerations of plagiarism, authorship, conflict of interest, and utilization of the findings of the study is very essential. So, in brief, today we have learned about what is nursing research, why it is important, what are the steps of quantitative research, and what are the steps of qualitative research. And it's very important to conduct a research in a systematic, planned way and disseminate the findings at the end. And most important is, after dissemination, it's not to keep in the libraries your study. Do a study which can be utilized, which can bring in the evidence to improve the patient care, to improve the nursing education, and to improve the decision making in nursing. I hope this session will help you to conceptualize the overall basic steps of the nursing research. Thank you so much.
Dear learners, welcome to IGNOU. You're going to lead with a difference. So how do you lead with the difference? The unique attributes of the university system through which you're going to go for the management program or any other program is the multiple entry and exit. It provides flexible learning where a learner can learn at its own will and at its own pace. It offers multimodal approaches like we have MBA, the normal through the distance learning mode and through online mode. So it has a multimodal approach. It has face-to-face counseling. It offers web counseling also. It gives interactive satellite-aided communication network through teleconferencing, and it also gives the radio counseling also. When we talk about School of Management Studies, it was the first school and it had the pioneer program of diploma in management. Till date, it has been offering around 14 programs in management and 13 programs in commerce disciplines. The school has international presence as well, as it provides the programs in specific Asian and African countries across the globe. Now talking about Master of Business Administration. What are the objectives? What are the learning objectives of this Master of Business Administration? What are the unique features of this Master of Business Administration which IGNOU is offering? Let us see the program at a glance. The program name is MBA, and the eligibility criteria for this program is bachelor's degree, minimum of 3 years duration with at least 50% marks and 45% marks in case of the reserved category. The duration of the program is minimum 2 years and maximum 4 years, and the program fee per semester is 15,500. The total credits of the program, the total credits are 116 because there is one project course which is equivalent to 2 courses. So it comes out to be 29 courses. If a student wants to exit the program after completion of the specified courses available in the first and second semesters, that is 56 credits if the student completes, then there is an exit option available. The award of postgraduate diploma in management on the request of the student if the student wants to exit. Apart from this, there are 4 stand-alone PG diplomas also, which are a different part. They don't fall a part of the management program. They are the stand-alone diplomas. That is postgraduate diploma in human resource management, postgraduate
नमस्कार। इग्नू जैसा कि आप जानते ही हैं जन जन का विश्वविद्यालय है। इसमें जन जन का स्वागत है। मैं पुष्पा। आज मैं आप लोगों के लिए लेकर आई हूँ MSK स्नातकोत्तर कला उपाधि संस्कृत कार्यक्रम का एक पाठ्यक्रम, उसका भी एक छोटा सा अंश। MSK एक बृहद कार्यक्रम है। इसका एक पाठ्यक्रम है जिसका नाम है दर्शन, सांख्य, वेदांत, योग और मीमांसा। ये जो तीसरा आपका पाठ्यक्रम है, इस पाठ्यक्रम के अंतर्गत आप जैसा कि जानते हैं, जिन लोगों ने इसमें लिया है, इसको चयन किया है, वो बहुत अच्छी तरह से जानते हैं कि ये तीसरा प्रश्न पत्र है, इसमें आप भारतीय दर्शन के विषय में अध्ययन करेंगे। भारतीय दर्शन के विषय में मैं आपको बताऊं, उससे पहले मैं आपको यह बता देती हूँ, सांख्य दर्शन में प्रतिपादित प्रकृति और पुरुष का स्वरूप, ये मेरा आज का विषय रहेगा जो आपको इस पाठ्यक्रम के अंतर्गत पढ़ना है। दर्शन जैसा कि आप जानते हैं और कि कैसा विषय है, ये बहुआयामी विषय है। इस कार्यक्रम का नाम है स्नातकोत्तर कला उपाधि संस्कृत कार्यक्रम और इस जो पाठ्यक्रम है इसका कोड है MSK 003। भारतीय दर्शन, हम लोगों ने कई बार सुना है दर्शन दर्शन, तो हमारे मन में आता है कि दर्शन क्या है। प्रत्येक व्यक्ति का अपना एक दर्शन होता है। हम जब बात करते हैं प्रत्येक व्यक्ति की, तो हम व्यष्टिगत दर्शन की बात करते हैं, लेकिन जब हम समष्टिगत दर्शन की बात करते हैं तो हम समूह की बात करते हैं, समग्र की बात करते हैं। और फिर वहीं पर जब हम कह देते हैं भारतीय दर्शन, जब हम भारतीय लगा देते हैं, तो इसका मतलब है भारतीय लगाने से कि इसमें जो विदेशी दर्शन है, यानी कि जो पाश्चात्य दर्शन है, उससे हम अपने इस भारतीय दर्शन को अलग करते हैं। तो भारतीय दर्शन 9 प्रकार के हैं, जिसमें से 6 आस्तिक और 3 नास्तिक हैं। जैसा कि आप देख भी सकते हैं, सांख्य, योग, न्याय, वैशेषिक, पूर्व मीमांसा और उत्तर मीमांसा, यह आस्तिक दर्शन है। इसके अतिरिक्त 3 चार्वाक, जैन और बौद्ध दर्शन नास्तिक दर्शन की श्रेणी में आते हैं। आपके मन में बहुत ही स्वाभाविक सी बात है कि ये प्रश्न उठेगा, आस्तिक और नास्तिक, जो अभी तक हम सुनते आए हैं कि जो ईश्वर पर यकीन नहीं करते वो आस्तिक और जो ईश्वर पर यकीन करते हैं वो नास्तिक। नहीं, इसका अभिप्राय यहाँ पर दर्शन के अर्थ में यह बिल्कुल भी नहीं है। आस्तिक का अभिप्राय है जो वेदों की सत्ता को प्रमाण मानते हैं, वेदों में लिखी हर बात को प्रमाण मानकर उसी के अनुसार अपनी क्रियाओं को करते हैं, उसी के अनुसार अपना जीवन यापन करते हैं, वो हैं आस्तिक पद का अनुगमन करने वाले आस्तिक दर्शन। और नास्तिक दर्शन जो वेदों की सत्ता को प्रमाण के रूप में स्वीकार नहीं करते। चार्वाक, जैन और बौद्ध 3 ऐसे दर्शन हैं जो नास्तिक दर्शन की श्रेणी में आते हैं। आज मैं आप लोगों के समक्ष जो विषय लेकर प्रस्तुत हुई हूँ वो है सांख्य में प्रतिपादित पुरुष और प्रकृति। तो सांख्य दर्शन, अब कोई भी जो दर्शन है वो किससे संबंधित है, उसकी बहुत सारी शाखाएं हैं, जिनमें से हम उनको देखते हैं तत्व मीमांसा, ज्ञान मीमांसा और मूल्य मीमांसा। तत्व मीमांसा की जब हम बात करते हैं तो जिसको हम इंग्लिश में बोलते हैं मेटाफिजिक्स, इसका मतलब है कि जब हम तत्वों का विचार करते हैं, ये संसार कितने तत्वों से बना है, कैसे बना है, क्या इसका अभिप्राय है, और ये जो वो तत्व हैं उनका सार रूप में अभिप्राय क्या है, क्या वो आज किसी भी प्रकार से हमारे सामने हमको दृष्टिगोचर होते हैं अथवा नहीं, कौन कौन से वो तत्व हैं। जब हम ज्ञान मीमांसा की बात करते हैं तो वो ज्ञान का विज्ञान अर्थात जिसको हम एपिस्टीमोलॉजी भी कहते हैं। ज्ञान की क्या प्रक्रिया है, किस प्रकार से ज्ञान होता है। जब हम दर्शन पढ़ते हैं, न्याय वैशेषिक दर्शन ही देख लीजिए, उसमें जब हम देखते हैं कि हम उसमें देखते हैं इंद्रियार्थ सन्निकर्ष, हमारी इंद्रिय उस विषय क्षेत्र में जाती है और वहाँ उस वस्तु का जो भी रूप है, आकार है, उसको ग्रहण करके लाती है। फिर वो किस किस क्रम से किस किस इंद्रिय को सौंपती है और अंत में किस प्रकार से हम ज्ञान का अनुभव कर पाते हैं या ज्ञान की प्राप्ति हम कर पाते हैं, वो हमारा जो विषय है वो ज्ञान मीमांसा का विषय होता है। मूल्य मीमांसा की जब हम बात करते हैं, जिसको हम एक्सियोलॉजी कहते हैं, अर्थात मूल्यों का विज्ञान। मूल्यों का विज्ञान अर्थात जब हम नैतिकता, अहिंसा, धर्म, हमारी मानवता, किस प्रकार से हमें कैसा व्यवहार करना है, क्या हमारा मत है, किस प्रकार से हमें आचार, हमारे व्यवहार, हमारे जो धार्मिकता है, जितने भी हमारे व्यवहार से सारी क्रियाएं हैं, व्यवहार से संबंधित मूल्य जो हमारे लिए अमूल्य हैं, जिनका कोई भी मूल्य नहीं है, जो हमारे जीवन को वास्तव में सफल बनाते हैं, वह मूल्य मीमांसा के अंतर्गत आते हैं। ये कोई भी जो दर्शन है उसके ये तीनों शाखाएं, इसके अतिरिक्त और भी हैं, परंतु तत्व मीमांसा, ज्ञान मीमांसा और मूल्य मीमांसा होती हैं। लेकिन आज का जो मेरा विषय है, तत्व मीमांसा को आधार बनाकर ही मैंने अपने विषय को चयन किया है। सांख्य किस प्रकार से 25 तत्वों को स्वीकार करता है? 25 तत्वों को स्वीकार करता है, सांख्य है क्या? आपके मन में प्रश्न आएगा कि सांख्य क्या है, तो इस पर हम थोड़ा सा एक बार एक दृष्टि डाल लेते हैं संक्षेप में। सांख्य दर्शन के प्राचीन प्रवर्तक कपिल मुनि माने जाते हैं। सांख्य सूत्र पर आधारित सांख्य कारिका सबसे प्राचीन ग्रंथ है। जैसे हम बात करते हैं सांख्य कारिका हम पढ़ते हैं, विश्वविद्यालयों में हमारे पाठ्यक्रमों में लगी हुई है और इसका हम अध्ययन भी करते हैं, अध्यापन भी करवाते हैं। सांख्य सूत्र इसका मुख्य आधार ग्रंथ है और यह इसका एक प्रकरण ग्रंथ है। प्रकरण यानी कि उसके कुछ भाग को लिया हुआ है, समाविष्ट किए हुए है, संपूर्ण को नहीं। सांख्य सूत्र का प्रकरण ग्रंथ है सांख्य कारिका, जो कि ईश्वर कृष्ण के द्वारा रचयिता है इसके, यानी कि उनके द्वारा इसको लिखा गया है। उन्होंने सांख्य कारिका को लिखा, लेकिन आधार किसको बनाया? सांख्य सूत्र को, क्योंकि वो उनका आधार ग्रंथ था। सम उपसर्ग ख्या धातु अंग प्रत्यय टाप प्रत्यय लगाने पर संख्या शब्द बना। फिर जब इसमें हम अण प्रत्यय लगा देते हैं तो सांख्य शब्द निष्पन्न होता है। सांख्य शब्द का अभिप्राय है, वो तो जैसे हम समझते हैं अपनी बुद्धि के अनुसार, सामान्य व्यक्ति भी संख्या यानी कि सांख्य, संख्या से के बाद अण प्रत्यय लगा के बना सांख्य, जो कि संख्या से संबंधित है। इस दर्शन में 25 तत्वों की गणना की गई है। 25 तत्वों के आधार पर यह ग्रंथ, यह दर्शन, समग्र जो सांख्य दर्शन है, इसका पूरा प्रतिपादन हुआ है। तो 25 तत्व कौन कौन से हैं? एक तो वो 25 तत्व, दूसरी दृष्टि से इसको दूसरा अभिप्राय हम जाने तो उन 25 तत्वों का जहाँ पर हमको सम्यक रूप से, भली भांति रूप से अध्ययन करने के लिए मिलता है, जहाँ पर समग्र का सम्यक रूप से हम अध्ययन कर पाते हैं, वही है सांख्य दर्शन। अब सांख्य दर्शन में 25 तत्व क्या हैं? 25 मैंने कई बार बता दिया, 25 तो सांख्य दर्शन के हम 25 तत्व देखते हैं। 25 तत्व समस्त जो सृष्टि है, यह इस 25 तत्वों के अंतर्गत ही समाहित है, जिसमें प्रकृति और पुरुष ये दो मूल तत्व हैं, जिनको आधार बनाकर संपूर्ण सृष्टि हुई है। अब जो प्रकृति है, ये कैसी है? अव्यक्त रूप में। जब यह अव्यक्त रूप में रहती है, सत्व, रजस, तमस त्रिगुणात्मक प्रकृति है, 3 इसके गुण हैं। जब यह किसी भी प्रकार से कोई भी सृष्टि नहीं करती है, जब इसकी साम्य की अवस्था होती है, तीनों गुण साम्य की अवस्था में होते हैं, एक ही अवस्था में रहते हैं, कोई गुण बढ़ के या कोई छोटा नहीं रहता है, समानता के भाव से रहते हैं, वही है कौन सी अवस्था? प्रलय की अवस्था। लेकिन जब किसी गुण में उद्रेक होता है, सत्व, रजस, तमस, किसी भी गुण में कोई ऊपर उठेगा, कोई नीचे उठेगा, तब उस वक्त सृष्टि की अवस्था होती है। समानांतर काल में तो क्या होगा? प्रलय की अवस्था होगी। जब उद्रेक होगा न्यून अतिशय भाव से, तभी सृष्टि होगी। तब जब प्रकृति अपने व्यक्त रूप से व्यक्त रूप में आती है, जब वो अपने अव्यक्त रूप से व्यक्त में आई, अव्यक्त कब? जब तीनों गुण समान रूप से हैं, कोई भी गुण सत्व, रजस, तमस बढ़कर नहीं है, साम्य की अवस्था है, वो प्रलय की अवस्था है। लेकिन सृष्टि की अवस्था में जब प्रकृति हमारे सामने इस संसार को बनाती है समग्र चीज़ें, ये पंखा, ये लड़की, ये मेज, ये कुर्सी, ये दीवार, ये पलंग, सब चीज़ें हमको दृष्टिगत हमको दिखाई देती हैं प्रत्यक्ष तौर पर, वो है उद्रेक की अवस्था, जब तीनों गुण साम्य की अवस्था में नहीं होते। तब सबसे पहले प्रकृति क्या करती है? लेकिन प्रकृति कैसी है? जड़ है, अचेतन है, अकेली स्वयं कुछ नहीं कर सकती। इसके लिए उसको सानिध्य की आवश्यकता होती है, पुरुष के सानिध्य की। और पुरुष कैसा है? चेतन है। चेतन के सानिध्य से प्रकृति अपने आप को चेतनवत मानने लगती है और फिर सारी सृष्टि होती है। और सृष्टि का जो क्रम है, सबसे पहले जब अव्यक्त प्रकृति अपने व्यक्त रूप में आती है, सर्वप्रथम महत की उत्पत्ति होती है, जिसको हम बोलते हैं बुद्धि तत्व। बुद्धि से उत्पन्न होता है अहंकार, और उसके बाद उत्पन्न होती हैं अहंकार से ही 11 प्रकार की इंद्रियां और 5 प्रकार की तन्मात्राएं उत्पन्न होती हैं। 11 प्रकार की इंद्रियां, अब आपके मन में प्रश्न उठेगा 11 प्रकार की इंद्रियां कौन सी हैं? ज्ञान इंद्रियां जिसको हम कहते हैं, इंग्लिश में हम अभी तक पढ़ते आए थे सेंस ऑर्गन, जो 5 प्रकार के हैं। हमारी दोनों आँखें, दोनों हमारे कान, हमारी नासिका, हमारी जिह्वा का अग्रभाग और त्वक यानी कि हमारी त्वचा, 5 ये जो सेंस ऑर्गन है, इसको हम ज्ञानेंद्रियों के रूप में जानते हैं। और कर्मेंद्रियां हैं 5, वो कौन सी है? वाक, पाणी, पाद, पायु, उपस्थ। और एक है इंद्रिय मन, वो दोनों में आती है, ज्ञानेंद्रिय में भी आती है और कर्मेंद्रिय में। वो उभयवादी इंद्रिय है जिसको हम मन के रूप में जानते हैं, वो दोनों के साथ रहती है। तो 5 ज्ञानेंद्रियां और 5 कर्मेंद्रियां। अब वाक, पाणी, पाद, पायु, उपस्थ। वाक हम जो बोलते हैं शब्द, पाणी हमारे हाथ, पाद हमारे पैर, पायु और उपस्थ एक हमारा मलमूत्र विसर्जन, मलमूत्र का विसर्जन वाला पार्ट, और एक हमारी मूत्रेंद्रिय, एक मल का पार्ट और एक मूत्रेंद्रिय जो हमारे गुप्तांग हैं उससे संबंधित है। और इन दोनों के अतिरिक्त एक है मन, जो उभयवादी इंद्रिय, जो दोनों के साथ रहता है। जब हम बात करते हैं कि 11 इंद्रियों की, उन समूह में तो ये शामिल है 11 इंद्रियां किसी भी प्रकार से किसी भी चीज़ को उत्पन्न करने में असमर्थ हैं, लेकिन 5 प्रकार की तन्मात्राएं, तन्मात्रा क्या है? शब्द, स्पर्श, रूप, रस और गंध। 5 प्रकार की तन्मात्राओं से पंच महाभूत की उत्पत्ति होती है। पंच महाभूत कौन कौन से हैं? पृथ्वी, जल, तेज, वायु और आकाश। इनसे पंच महाभूतों की उत्पत्ति होती है। अब जैसे जैसे हम आगे बढ़ते जाते हैं सृष्टि के क्रम में, ये तो हो गई सृष्टि की अवस्था, और प्रलय की अवस्था में भी हम देखते हैं कि जैसे जैसे जो जो चीज़ जिससे उत्पन्न होती है, वो वस्तु या वो पदार्थ उसी में, उसी अपने आधार में, अपने अपने कारण में वो कार्य लीन होता जाता है। उसी को हम सत्कार्यवाद के नाम से भी सांख्य दर्शन में जानते हैं। सत्कार्यवाद का सिद्धांत क्या है? सत्कार्यवाद का सिद्धांत यही सिद्धांत है कि हमसे कहता है कि कोई भी कारण हो, उस कारण का जो भी कारण है, उस कारण का जो कार्य होता है, वो कार्य अपने कारण में सतरूप में विद्यमान रहता है। सतरूप में यानी कि चेतन अवस्था में विद्यमान रहता है, तभी तो उससे घड़ा, कुल्हड़, मटका, शकोरा, गमला इत्यादि वस्तुओं की उत्पत्ति होती है। और इसमें कारण क्या है? मृत्तिका यानी कि मिट्टी। मिट्टी से ये सारी चीज़ें उत्पन्न हुई हैं। तो मिट्टी क्या है यहाँ पर? कारण। और कार्य क्या है इसके? जितनी सारी चीज़ें इससे उत्पन्न हुई हैं वो सभी इसके कार्य हैं। कॉज और इफेक्ट, ये थ्योरी आप अलग रूप में भी इसको पढ़ते और समझते आए हैं। वही सांख्य दर्शन कार्य कारण सिद्धांत के रूप में बताता है। ये सत्कार्यवाद का सिद्धांत की पुष्टि करता है। तो वो ये कहता है कि प्रकृति ने सारी चीज़ों को उत्पन्न किया है। प्रकृति त्रिगुणात्मक है, इसलिए उसके द्वारा उत्पन्न सभी चीज़ों में, सभी उसके जो भी विकार हैं, यानी कि उनसे जो जो चीज़ें उत्पन्न हुई हैं, सभी चीज़ों में वो प्रकृति वाली विशेषताएं पाई जाती हैं। प्रकृति त्रिगुणात्मक है। कैसे? कि उसमें सत्व भी है, रजस भी है, तमस भी है। मात्राएं न्यून आधिक्य भाव से किसी में ज़्यादा, किसी में कम हो सकती हैं। इस सृष्टि प्रक्रिया पढ़ने के बाद आज हमारा विषय है पुरुष और प्रकृति का स्वरूप सांख्य दर्शन के अनुसार। तो सांख्य दर्शन कहता है कि पुरुष कैसा है इसमें चेतन, और पुरुष कैसा है अनाश्रित और उदासीन। उसकी कोई इच्छा नहीं है कि वो सृष्टि कार्य में प्रवृत्त हो, या वो किसी पर आश्रित भी नहीं है, अनाश्रित है वो, उसको किसी ने उत्पन्न नहीं किया, कहने का अभिप्राय। पुरुष कैसा है, उसका कोई अवयव नहीं है, सा अवयव नहीं है, निरअवयव है, स्वतंत्र है, कोई किसी के वो अधीन नहीं है, किसी के वो मतलब किसी का वो गुलामी या किसी का वो अधीनस्थ कार्य नहीं करता है, वो पूरी तरह से स्वतंत्र है, चेतन है पुरुष। उसकी चेतनता का लाभ लेकर ही प्रकृति उसके सानिध्य के साथ सृष्टि करती है और समग्र सृष्टि हमको दिखाई देती है। पुरुष कैसा है, बहुत्वम, उसकी एक संख्या नहीं है। और यहाँ हम जब दर्शन की बात करते हैं तो यदि हम पुरुष को इस रूप में समझें, आत्मा के रूप में, केवल समझने के अभिप्राय से, तो शायद हम ज़्यादा अच्छी तरह समझ पाएंगे। प्रत्येक व्यक्ति नहीं, या व्यक्ति व्यक्ति करके पुरुष यदि हम समझेंगे तो इतनी अच्छी तरह से हम नहीं समझ पाएंगे। यदि हम इसको आत्मा के रूप में समझें तो यह हमारे लिए ज़्यादा समझने में बहुत आसानी होगी। कैवल्य की ओर इसकी प्रवृत्ति देखी जाती है। यहाँ पर एक सूत्र, एक कारिका आती है। सांख्य जो कारिका है, इसमें कारिकाएं हैं, 70 कारिकाएं। तो इसमें एक कारिका आती है, संघात परार्थत्वात्। संघात यानी वस्तुओं का समूह, ये किसके लिए होता है, दूसरों के लिए होता है। प्रकृति सृष्टि करती है, खुद उन वस्तुओं का किसी प्रकार से सेवन नहीं कर सकती, तो सेवन करने के लिए कौन है, चेतन तत्व होना चाहिए, वो है पुरुष। वो है पुरुष। त्रिगुणादि विपर्यात, तीनों गुणों की जिसमें विपरीतता हो, जिसमें तीनों गुणों का अभाव हो। प्रकृति में तीनों गुण हैं, लेकिन पुरुष तीनों गुणों से रहित है। और उसकी क्या क्या विशेषता है, उसमें वो कहते हैं कैवल्य की ओर जिसकी प्रवृत्ति देखी जाए। अधिष्ठानात, जो किसी चीज का अधिष्ठान हो, जैसे रथ है, उसको चलाने वाला एक सारथी है, चाहिए ही चाहिए, रथ अपने आप स्वयं नहीं चलेगा। अब प्रकृति ने ये सारे चीज़ों को दे दिया हमको, संपूर्ण संसार की समग्र चीज़ों को, वस्त्र दे दिए, ये आभूषण दे दिए, और हमको ये सारे फुटवेयर दे दिए। अब इनको ग्रहण करने वाला भी कोई होना चाहिए। तो अधिष्ठान के रूप में पुरुष की सिद्धि, फिर कैवल्य की ओर प्रवृत्ति, ये भी पुरुष की देखी जाती है। पुरुष की देखी जाती है, क्यों कह रही हूँ, इसलिए क्योंकि पुरुष चेतन है। कैवल्य की ओर प्रवृत्त कौन होगा, कैवल्य अर्थात निर्वाण, अर्थात अपवर्ग, अर्थात मोक्ष। अलग अलग दर्शन में इसको अलग अलग नामों से पुकारा गया है, सब इसके पर्यायवाची हैं। बात एक ही है, त्रिविध दुखों से मुक्ति। संसार में त्रिविध दुखों से मुक्ति। त्रिविध दुख क्या है, आदि दैविक, आदि भौतिक और आध्यात्मिक। त्रिविध दुखों से मुक्ति के लिए यदि व्यक्ति प्रयास करना चाहता है, सांख्य दर्शन में पहली कारिका में यही बताया है, त्रिविध दुखों से मुक्ति करने के लिए सांख्य दर्शन में प्रवृत्त होना चाहिए, सांख्य दर्शन को पढ़ना चाहिए, इसका अध्ययन करना चाहिए। क्योंकि संसार में जो और उपाय हैं वो किसी न किसी दोष से युक्त हैं, परंतु यदि आप सांख्य दर्शन को यदि आप अपनाते हैं, उसका अध्ययन करते हैं, त्रिविध दुखों से मुक्ति होगी। जैसा आप जानते हैं, अभी तक आप अध्ययन करते आए हैं, सभी दर्शनों का मूल क्या है, मोक्ष की प्राप्ति, त्रिविध दुखों से मुक्ति। और ये मुक्ति का कौन सा मार्ग है, मुक्ति का मार्ग तभी प्राप्त हो सकता है जब आवागमन से हमारा जो जीवन है पूरी तरह से मुक्त हो जाए। आवागमन से मुक्ति कब होगी, जब हम इस शरीर के बंधन से मुक्त हो जाएं। शरीर के बंधन से मुक्ति कब होगी, जब हम कर्मों से हमको निजात मिल जाए। और कर्म से निजात कब मिलेगी, जब हम कर्म फलों से मुक्त हो जाएंगे। तो कर्म फलों से मुक्त होने का एकमात्र रास्ता सांख्य कारिकाकार कहता है, ईश्वर कृष्ण कहते हैं कि आपको सांख्य कारिका को अध्ययन करना चाहिए। यदि आपने सांख्य के बताए मार्ग को यदि आप अनुसरण करते हैं तो निश्चित तौर पर आप एक दिन मोक्ष के रास्ते पर प्रवृत्त होंगे। पुरुष कैसा है, चेतन है। जब वो जान लेता है कि पूरी तरह से उसको ये पता चल जाता है कि जो प्रकृति है वो मेरे लिए केवल भोग दे रही है, मुझे केवल इस्तेमाल कर रही है, मैं केवल भोगों को करने वाला हूँ, मैं केवल भोगता हूँ, मैं करने वाला नहीं हूँ, मैं किसी भी चीज़ का मुझ पर अधिकार नहीं है, मुझे केवल इस्तेमाल किया जा रहा है। और प्रकृति को लगता है सारे भोग मैंने इसको दे दिए, अब मैं इसको किसी प्रकार भोग नहीं दूंगी। प्रकृति उसके लिए भोगों को संपादित करना बंद कर देती है। और जो पुरुष है उसकी कैसी वो इच्छा होती है कि मैं इनको भोगना नहीं चाहता हूँ, इन भोगों को, और प्रकृति को लगता है मैं इसको क्यों दूं। और फिर तब प्रकृति उससे निरत हो जाती है और पुरुष कैवल्य की ओर प्रवृत्त हो जाता है। और यही सांख्य दर्शन का लक्ष्य है, किसी भी दर्शन का ध्येय है। सांख्य दर्शन में पुरुष और जो प्रकृति है उसके संयोग से सृष्टि होती है। अब सृष्टि कैसे होती है, यहाँ पर एक दृष्टांत बताया है। जिस प्रकार से एक अंधा व्यक्ति जो कि देख नहीं सकता और एक जो लंगड़ा व्यक्ति, ये पंगु व्यक्ति है, वो चल नहीं सकता, दोनों यदि सहयोग करते हैं और मिलकर वो क्या करते हैं, एक कठिन से कठिन जंगल को, कठिन से कठिन मार्ग को तय कर लेते हैं, उसी प्रकार से पुरुष की चैतन्य शक्ति पंगु के समान है क्योंकि वो, और प्रकृति की क्रिया शक्ति क्योंकि वो एक नेत्रहीन के समान है। दोनों मिलकर सृष्टि कार्य को करते हैं, अपने अपने जो भी उनके लक्ष्य हैं उनको संपादित करते हैं। प्रकृति और पुरुष का संयोग होता है, संयोग, और उन संयोग के द्वारा क्या होता है, सर्ग अर्थात सृष्टि होती है, सृष्टि का निर्माण होता है। और सृष्टि के निर्माण के उपरांत फिर जैसे जैसे क्रम आता है फिर उस सृष्टि का प्रलय होता है। तो यह जो क्रम है दर्शन के अनुसार चलता ही रहता है, सृष्टि, प्रलय, फिर पुनः सृष्टि, पुनः प्रलय। तो यह जो क्रम है ये लगातार चलता है। जैसा आप सभी जानते हैं, हम भी जानते हैं, सृष्टि का ये क्रम है। उस क्रम के अधीन ही मैं भी बंधी हुई हूँ और आप भी, और जिसके कारण अब मैं भी घड़ी की सुइयों को देख रही हूँ और मेरा जो समय है वो समाप्त होने वाला है। और आपके साथ में अगला विषय लेकर फिर आऊँगी। आज मैं आपको अपनी यहीं पर बात, अपनी विराम लगाती हूँ इतनी बात कहकर कि सृष्टि जो ये प्रकृति और पुरुष दोनों अपने सानिध्य से करते हैं और फिर अंत में प्रलय होती है। तो सृष्टि का जो यह चक्र है, सृष्टि के बाद प्रलय, फिर वापस सृष्टि, तो ये चक्र लगातार चलता रहता है, ये कभी भी थमने वाला नहीं है। परिवर्तनशील संसार है, परिवर्तन संसार का नियम है। इस परिवर्तन को हम सभी को अपनाना है, यही सांख्य दर्शन कहता है। अगला दर्शन आपके समक्ष अगले सेशन में हम लेकर उपस्थित होंगे। आप सब लोगों को बहुत बहुत धन्यवाद मुझे सुनने के लिए। नमस्ते।